Can I circle back to something Justice Alito asked? He asked you what the scope of, if you thought there was constitutional preemption as a principle. And you said yes, I believe, but correct me if I'm wrong. And I wanted to know, is uniquely federal interest a branch of constitutional preemption in your view?
We believe it's a branch of federal common law preemption, Your Honor. So,
what's the difference then between what you're calling constitutional preemption and federal common law preemption as to the concept of uniquely federal interest, or is there any difference at all?
So what I was talking to Justice Alito about was cases like U.S. v. Washington and Penn-Dairies and North Dakota.
Can you just answer my question? Is there any difference?
There is a difference, Your Honor.
What is the difference?
The difference is one comes from the structure of the Constitution and this Court's decisions.
Difference in application. Is there any difference in application? I'm sorry.
I mean, yes, Your Honor, because one is saying that states cannot act in a discriminatory manner against a contractor, and the other is that you're displacing the operation of the entire state law from that area. So when it comes—
Unless Congress specifies otherwise. Always important to put that on there. Congress could provide for state tort law in this area. That's my point, which is this whole whole case, in my view, starts with what's your baseline? State tort law regulating military contractors in a war zone. Is your baseline that Congress has to speak to displace that, or that Congress has to speak to provide for that? And I would think our uniquely federal interest branch of preemption law makes, I thought, fairly clear that Congress would have to speak to provide for that. And look, what happened here is terrible, so I'm completely sympathetic to that. But in terms of the legal framework that applies for situations like this, my thought, based on the precedent, was Congress has to speak to provide for it.
we don't think so, Your Honor. Given cases like Little and Mitchell, we think the default is that common law rule is in place unless Congress affirmatively displaces the operation of state.